the huge gun case up in New York, where I couldn't get a gun in New York. I had 15 active threats. I had Gavin Beck and Associates, they're probably the best security detail in the country, in the world, really. And they were following these threats. You know, my kids were looking at pursuer lists on our refrigerator. If these people approached, go run, get mom or dad. I mean, it was really bad. And I couldn't get a gun in New York City because they deemed that I didn't have enough cause to have a gun. That's been thrown out now. So tell me what they've done. What does this mean for New York and the rest of the country?
So it's a fantastic ruling. Look, I have not had the chance to pour through this with a fine-tooth comb. Looks like the Justice Thomas majority opinion clocks in at 63 pages, you know, including concurrences and dissents. We're up to 130, 140 pages. So I've got my reading cut out for me for the rest of the day. But based on my quick skimming of it, this is a thoroughly well-researched, I might even say thus far, career-defining majority opinion from Justice Clarence Thomas.
Wow.
It's really interesting. I was thinking about this recently. It's unclear to me to date, or at least before today, whether Clarence Thomas had a career-defining majority opinion. He's written so prolifically for so long, but most of his greatest writings, especially on the hard-hitting cases, have been in concurrence or more often than not, oftentimes in dissent. Really, Antonin Scalia, I think in another gun case, 2008 DC versus Heller, had his kind of landmark career-defining opinion. And at least until affirmative action, I predict, is likely overturned next term, we can get to that if you want to, at least until that day where I predict Thomas would also have the majority opinion, this is his career-defining opinion. This is an issue that is very near and dear to Justice Thomas. He wrote an amazing concurrence in the court's last major Second Amendment case, the McDonald versus City of Chicago case from 2010, where he had a magisterial 55 to 60-page concurrence just working through the history. This issue is very near and dear to him. He's a personal gun owner. He enjoys hunting. And from what I can tell, it's just a really thoroughly well-researched opinion that reaches the clear and obvious result that anyone with any degree of familiarity with the Second Amendment text could tell you, which is that this is a right. And the very act of talking about bearing arms, not just keeping them, but bearing them, obviously entails the ability to do so outside the home without oppressive restrictions, the likes of which, Glenn, it sounds like you faced in my home state of New York. And a point that Justice Kavanaugh makes in his very brief concurring opinion, he kind of just drives home this point, which is the vast majority of states which have so-called shall issue regimes for their gun licensing permits, which means that you have to give the applicant a permit as long as they go through XYZ test. You know, they shoot the right number of targets, similar to what I did in Texas when I got my permit there years ago. Those laws are all untouched. The only laws that are jeopardized by today's decision are the more problematic, quote-unquote, may issue laws, not the shall issue laws, where they basically give the licensing authorities a ton of discretion to arbitrarily decide where you have to, you have to show that you truly, truly need it, whatever the heck that means. But, Glenn, the fact that you couldn't get it, go ahead.
Yeah, is nuts. So I wanted to ask you, so doesn't this make the Senate gun bill a joke? I mean, that will have no teeth to it after this ruling, would it?
Yes and no. It's really interesting. I expect a lot of the commentary over the next 24 to 48 hours leading into next week is going to focus on this exact question, right? So in theory, they are different issues. The ruling here today is talking about concealed carry and open carry licensing regimes in the states. The Senate gun bill is in theory focused on other measures. It's focused on things like red flag laws, but it is a little intellectually inconsistent, or at least at a bare minimum, it would be a little peculiar, right, to have a liberalized, and I say that in a good way, a more liberalized concealed carry licensing regime, while at the same time having a red flag law in place that would just infringe upon due process rights willy-nilly. Those two things would seem to be in tension with one another. At a bare minimum, the timing
but it's
of
not
the release of this opinion, it really kind of sucks the wind out of John Cornyn and the other 13 Senate Republicans' momentum, that's for sure.
So how will this affect other states? New York, by the way, has just come out, and I'm going to talk about this in a minute. New York has already come out and said it's not going to change anything. We're not going to abide by this, which is ironic because that's what the Second Amendment is for, to stop an out-of-control, lawless government doing what they want and not abiding by the Constitution. I just want to point that out.
Well, that's wild. I have not seen that, but that's just wild stuff if they said it that bluntly here. Look, the entire idea behind the incorporation of the Bill of Rights, which is itself a legally debatable matter, I should say, but the court has held that the overwhelming majority of the enumerated rights in the Bill of Rights, including the Second Amendment, by the way, that's the McDonald versus Chicago case from 2010, the court has held that these rights are incorporated against the states, which, to escape the legalese for a minute, means that a state cannot infringe upon these rights. The federal government already cannot, but a state cannot as well. So this case is right out of New York State. So, if New York State wants to go, flip two middle fingers at the court when they itself are a party to the lawsuit, look, parties to the lawsuit are bound.
Let me read exactly what Governor Kathy Hochul said. She said, it's outrageous that at a moment of national reckoning on gun violence, the Supreme Court has recklessly struck down a New York law that limits those who can carry concealed weapons. By the way, I don't know if she knows this, but Buffalo is in New York, so her law didn't do anything. In response to this ruling, we are reviewing our options, including calling a special session of the legislature. Just as we swiftly pass nation-leading gun reform legislation, we will continue to do everything in our power to keep New Yorkers safe from gun violence. So she didn't say we're not going to do it. She said we're just going to find a way around it.
Right. That statement is about what I would expect from a left-wing hack like the governor of New York State. We'll see what they try to do. They'll try to pass some law. Maybe they'll try to issue something administrative. Inevitably, they'll find themselves in court again. And, with the current composition of the court, if that ultimately makes its way up to the Supreme Court itself, you have to like the odds of the side of gun rights. The reality is that if I have the number correctly, I think it's 43 of the current states in the country, if I recall the number from the Kavanaugh concurring opinion today, 43 of the states are either quote-unquote shall issue states or just straight-up constitutional carry states where you simply do not need a license to exercise your right to keep and bear arms outside the home. So we should note that this opinion does not actually apply to the vast majority of states. We're really only talking here about deep blue states such as New York State. And look, cynically speaking, as someone who was born in New York and fled many years ago, if it is oppressive laws like this that incentivize more people to flee blue state tyranny for red state freedom, far be it from me to criticize people to do so. But the statement that you read, Glenn, I would expect them to say something along those lines.
My producers are freaking out because they want to make sure that I clarify something here that I just said. Historically, the reason why the Second Amendment exists is not for hunting, not a sport. I want to go shoot clay pigeons. Okay, that's not what it was about. Otherwise, you might be able to find bowling in the Constitution and the Bill of Rights. It's not about a sport. It's about protecting yourself and protecting your community against an out-of-control rogue government. That's what it's about. So I just find it ironic that if they're like, we're not going to obey by this rule, that's what the Second Amendment, that's what the founders were talking about.
Right. But you're
somebody that just decides.
As you just read that statement, that's not exactly what's happening. You're not exactly calling for a civil war against Albany. I don't think,
God.
are you? I want to make sure here, because you're talking about this was the motivation at the time. You have to follow these traditions and these rules, but this is a much, much different case here as we're talking about it now from some statement from a meaningless,
I'm just talking about how ironic it is that that's what the founders said. That's really important because if they're, as George Washington said, when the people fear the government, there is tyranny. When the government fears the people, there is liberty. And part of that is being able to question them, to speak out, to have a free press, to assemble, and also to own a gun. Anyway, Josh, anything else that you see that came out today that you think is good news in a far-reaching way?
Well, first of all, let me just chime in briefly on the conversation that you and Stu were just having. I obviously could not agree with you guys more on the philosophical underpinning of the Second Amendment. Glenn, I know that you will uniquely appreciate this just because I know how much you care about this issue. But, I'm Jewish, obviously. I keep on my desk at all times a rock that a rabbi gave to me years ago that he smuggled out of the crematorium of Auschwitz. And I keep next to that rock a rock that I myself took from Treblinka. And then across my room, I have my Daniel Defense AR with lots of ammunition and mags and all that. And to me, I refer to that to my friends as my Warsaw Ghetto gun. So no one understands the philosophical underpinning of the Second Amendment more than I do. So I just want to echo your sentiments on that. It's very well said.
Yeah. The Germans gave all of the information of where their guns were to the Weimar Republic. You give it in good faith because the Weimar Republic said, "Oh, we'll never use this." Well, then the Nazis came in, and guess who took all the information and knew where all the guns were? That's why you just don't do these things. But anyway, go ahead.
Exactly. Shifting a little bit as far as other cases that came across the transom today. So there's an Eighth Amendment case about a method of execution that I have not had the chance to review yet. It's a case out of Georgia called Nance v. Ward. Long story short, there's been all sorts of kind of activist litigation for many years now where, the predictable groups, the ACLU, groups like that will sue, and they have the effect of incrementally outlawing or seeking to outlaw various forms of execution, which only then make you have to look harder and harder to find the right cocktail. It's a very pernicious legal tactic with the obvious and not so subtle end goal of trying to re-abolish the death penalty in America. It looks like the wrong side won today, but a glimmer of hope, though. I see that Justice Barrett actually filed a dissenting opinion in that case. So even though Kavanaugh defected, it's good to see that Justice Barrett, at least, is on the right side of this Eighth Amendment issue.
Okay, good.
Another case that I have not really fully had the chance to break down, it's out of the Fourth Circuit. It's a case in North Carolina. Basically here, it's a case called Berger versus North Carolina State Conference of the NAACP. The court ruled, and it's notable because it's an 8-1 ruling. It's an 8-1 ruling. They ruled that Republican state lawmakers in North Carolina are able to intervene to defend their state's voter ID law that the NAACP challenged. So the procedural posture there is not a substantive claim. It's more of a procedural claim. Rather, the reason I want to flag it for your listeners, I think it's worth discussing at least a little bit, is because it's an 8-1 opinion. The only person who dissented here is, predictably speaking, Sotomayor. And that's a real rebuke to the U.S. Court of Appeals for the Fourth Circuit, the lower court that heard this, when you get reversed 8-1 by the court, when everyone but Sotomayor disagrees with you. And it really paints a stark picture as to how much the Obama presidency changed the Fourth Circuit among some other circuits. So we really do have a long road ahead of us to get some of these lower courts back in order, unfortunately. But this case did come out the right way, I'm pleased.
Josh, thank you so much. This is Josh Hammer. He'll be joining us again tomorrow because more rulings are coming out tomorrow, and we're coming close to really big ones.